West Virginia's lease termination laws are relatively straightforward compared to more heavily regulated states, but there are specific rules you need to follow to do it properly. If you manage rental property in West Virginia, here's how termination works. As we discussed in our habitability video, West Virginia does not have a comprehensive residential landlord-tenant act. Instead, lease termination is governed by a combination of West Virginia Code Chapter 37, Article 6, which covers landlord and tenant relations, the state's unlawful entry and detainer statute in Chapter 55, Article 3A, and general contract law principles. For month-to-month tenancies, West Virginia requires either party to provide 1 full month's written notice before terminating. The notice must expire at the end of a rental period, so if rent is due on the first of the month, you'd need to give notice at least 1 full month before the first. For example, if you want the tenant out by March 1st, you'd need to deliver the notice no later than January 31st. Getting the timing right is important. An improperly timed notice can be challenged in court. For fixed-term leases, the lease expires at the end of the agreed term without requiring additional notice unless the lease specifically requires it. If the tenant stays beyond the lease term and the landlord continues to accept rent, the tenancy generally converts to a month-to-month arrangement under the same terms and conditions. Landlords who want to avoid this automatic conversion should send written notice well before the lease expires, making their intentions clear. For week-to-week tenancies, 1 week's notice is required from either party, and the notice must expire at the end of a weekly rental period. Now let's talk about termination for cause. For non-payment of rent, West Virginia doesn't have a specific statutory notice period like many other states. However, the common practice and the expectation under the unlawful entry and detainer statute is that the landlord provides the tenant with notice that rent is overdue and demands payment before filing a court action. Most landlords provide a written demand and allow a reasonable time, typically a few days, for the tenant to pay before proceeding to court. While this isn't as precisely defined as a 3-day or 5-day statutory notice you'd see in other states, West Virginia courts expect landlords to act reasonably and give the tenant at least some opportunity to pay before seeking eviction. For lease violations other than non-payment, West Virginia law does not prescribe a specific cure period. The process depends largely on the terms of the lease and the nature of the violation. If the lease includes provisions for termination based on specific violations, the landlord can enforce those terms after providing reasonable notice. For serious violations, like criminal activity, significant property damage, or conduct that endangers other tenants, the landlord can pursue eviction more aggressively, though the process still must go through the courts. West Virginia does have a specific provision for drug-related criminal activity. Under West Virginia Code Section 55-3A1, a landlord can pursue expedited eviction proceedings when a tenant or someone under the tenant's control is engaged in drug-related criminal activity on the premises. This provision was enacted to give landlords a faster path to removing tenants involved in drug crimes, and the courts can act more quickly in these cases than in standard eviction proceedings. For situations involving domestic violence, West Virginia provides some protections for victims. Under the state's domestic violence statutes, a tenant who is a victim of domestic violence and holds a protective order may have grounds to terminate the lease early without penalty. The specifics can depend on the circumstances and the terms of the lease, but courts generally look favorably on domestic violence victims who need to relocate for their safety. Active duty military members in West Virginia are covered by the Federal Service Members Civil Relief Act. They can terminate a residential lease early by providing written notice along with a copy of their military orders. The termination takes effect 30 days after the next rent payment is due following delivery of the notice. West Virginia strictly prohibits self-help evictions. Under the unlawful entry and detainer statute, landlords cannot change locks, shut off utilities, remove the tenant's belongings, or take any physical action to force a tenant out. All evictions must be processed through the court system. A landlord who engages in self-help eviction can face civil liability for the tenant's damages and may be subject to criminal penalties depending on the circumstances. The eviction process in West Virginia goes through the magistrate court system. The landlord files a complaint for unlawful entry and detainer, and the court issues a summons to the tenant. The hearing is typically scheduled within a matter of days or weeks. If the court rules in the landlord's favor, an order of possession is issued, and the tenant is given a specific period, usually a few days, to vacate. If the tenant doesn't leave voluntarily, the landlord can request that the sheriff enforce the order. One practical consideration for West Virginia landlords: because the state lacks a detailed statutory framework, your lease agreement is your most important tool for managing the termination process. A well-drafted lease should clearly define the grounds for termination, the notice requirements, what constitutes a material breach, and the consequences of specific violations. In a state where the statute provides broad strokes rather than detailed procedures, the lease fills in the critical details. West Virginia's court system is generally efficient for eviction proceedings compared to more backlogged jurisdictions. The magistrate court process is designed to handle landlord-tenant disputes relatively quickly, and cases typically move through the system faster than in states with specialized housing courts that may have heavy caseloads. One more thing to keep in mind: West Virginia has seen increasing attention to tenant rights in recent years, and there have been legislative proposals to strengthen tenant protections. While the current framework remains landlord-friendly, it's worth staying informed about potential changes that could affect how you manage lease terminations in the future. For the complete guide to West Virginia lease termination laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for every state in our series.